Patricia Van Haren, family law attorney. What is community property? Community property is any property that was acquired during the dates of the marriage of the parties up to the date of separation, unless that property was obtained through an inheritance or a gift. So looking at community property, the presumption is that it doesn't matter whose name the account is in. If money was accumulated during the marriage through an employer, a job, or some other means of generating income, then that income would be community property. And the bank account that it was put into would also be community property. A lot of people think that if the bank accounts are in their own name, there is no community property. And in California, this simply is not true. That also means the debts that are accrued during the marriage, regardless of the name on the credit card or the loan documents, will also be community property debts. Now, when we're going through a dissolution process, we're going to look at what are the debts that were accumulated and what are the assets of the parties. And really all of that's going to go into a balance sheet so that there can be an equal division of that community property. If you use separate property, such as money from an inheritance, to place a down payment on a house, for example, then you would be entitled to a reimbursement for the separate property interest in that house. However, it doesn't mean that you would receive the benefits of the accumulation of equity on that basis. You would receive really a dollar for dollar reimbursement. Sometimes community property and separate property can be very tricky. So the step is to make sure you are informed and educated and working with a family law attorney that is knowledgeable about both community property and separate property, especially as it relates to your individual situation.